Okay, thanks everybody for joining today. Today is part two of the Nielsen webinar series regarding trusts and estates. If you joined last weekend, even if you didn't, we'll continue this great conversation about preserving wealth during your life and after wills, trusts, and estates. As always, we'll be holding questions until the end, but you can feel free to type those in at any time in the question box. And with that, I turn it over to you, Daniel.
Thank you so much, Kelly. Apparently, people liked it enough that they came back for a second time. And if you missed last time, what were you thinking? I think it was the best talk I ever had because I had such a great audience. But I'm pretty sure you guys record your programs, so that would be great. So, just going over what we did last time that we spoke, which was last week at this time, we spoke about the first part of trust and estates, which was primarily based off of what are the very general documents that are required and what are some of the things that are out there for while you are alive that will make a difference if you become incapacitated. Now, this program is geared more toward leaving money to other people. This is like the more, I guess you call it, traditional way of viewing trusts and estates. So, as I said before, this I think is a great program. If you have questions, save them and we'll start going through it. So, without further ado, let's begin. So, this is part two of our trust and estates program. So again, what I always like to do is show you the disclaimer because once you see it, you can't unsee it. If you want to see it, you can always go back later. So what are we talking about today? We're talking about money. Duh, of course, that's what we're talking about. Minimizing taxes, avoiding court fees, and minimizing attorney fees. We're trying to maintain control of our assets after our lifetime in case, our husbands decide, hey, I'm going to marry that person 25 years younger than me, and you're worried your kids aren't going to get something. Yep, we do that too. Steps to minimize estate nightmares. Nightmares mean not just litigation like trial problems, it just means ways to avoid problems that would come up that even when everything is cool and everyone agrees, the court or the state just makes things harder. So the idea today is what we're going to be covering regards transferring properties outside of your will, retirement plans in your estate, wills and probate. Section 4 will be about using trusts correctly. And for those of you who may opt to do this on their own, which is perfectly fine, though I don't know why you would since your company covers legal insurance plans, so be it, avoiding unforeseen problems. I'll make one final comment. I'm working and talking to you from New York City, from Midtown Manhattan, so I will occasionally hear honking, I'll hear fire alarms, who knows what else it'll be, but unfortunately you'll have to partake in that experience too. I apologize, we're just stuck with it. And again, going over basically what we did last time, there are three aspects to your financial life. There is what I call the upper left-hand quadrant, the find, save, and protect. So every time you save in your 401k plan, every time you inherit something from perhaps a family member, or anytime you are rummaging through your closet and you say, hey, look at this, a rare baseball card that I forgot that I had bought years ago. On the left-hand side is investing and allocating. Basically, how do you allocate your investments? You don't just put all of your money in cash. If you're trying to earn money, you shouldn't be in cash. But if you're trying to maintain it, you probably should. But there may be better ways than just having it in plain green cash or even in a checking account. And then last but not least is minimizing fees and taxes. If you can master at least two of these categories, you should be able to have a positive growth in your net worth. If you can learn to master or take advice in all three of these categories, you are going to do particularly well, most likely better than your neighbor, and you deserve it. Now remember, we're talking today about assets, not income. Income is really all well and good, but we really don't control it. I mean, I guess you could ask your boss for a raise and he could say no, and then you don't really have control over it, or he could say yes, that's great, but you can't really rely upon it. And when you retire as well, it can't be changed very easily. You get a pension if you're one of these lucky people. If not, you get Social Security, which is kind of a government pension anyway. And your income is typically ongoing. You can't change it. It's reliable. It's like, whatever it is, that geyser in Yellowstone Park. It's reliable and it's ongoing, but you can't really change it. And you can only sometimes leave your income to another person, your spouse. Estate planning doesn't really deal much with income, believe it or not, because there's only one person who can possibly receive those typically, sources of income, and that is your spouse after you pass away. You could say, well, I own a rental home and I get rental income. Yeah, you own an asset. You don't own income, you own an asset. You never really own income, it's just something that comes in. We're talking about assets today. We love assets because you have complete control over your assets. So, for example, I can move my money from a checking account to Bitcoin to back to bonds and into stocks, and I can give it to whoever I want while I'm alive, and technically while I pass away as well. That's what estate planning is. So you can change its nature, you can change who owns it, and the other thing is that assets tend to be taxed at lower rates than income. So your stock that you bought, let's say you bought, what does everybody want to buy? Amazon. I bought Amazon 20 years ago. Yeah, you wish. And if you did, what are you doing on this webinar? Go out and go on vacation. But we're often taxed at lower rates on assets in the form of capital gains than our income is taxed at. We're talking about assets today. So your gross estate, meaning everything that you own for estate planning purposes, is your gross estate. It's everything you own. Non-probate estate is what transfers outside of your will. And your probate estate is what transfers under your will. You know, probate is a process. And it's a legal process that's controlled by the courts in whatever state you live in. Don't forget, most of the laws we live under are state laws. If you got divorced, it was under the state law of whatever law that the divorce took place in. If you get a traffic incident, most of the time it's based under state law. And a state law is the same thing. Estates is state law. So the process is called probate, and your court will have different names for the actual court, but the process is almost certainly going to be called the probate process. That's the process we use for your will. Going back up, though, non-probate, what is the legal process called? The legal process is called operation of law. We're going to talk about what that means. We also call these types of assets, non-probate assets, testamentary substitutes because they transfer outside of your last will and testament. They are testamentary substitutes. The big difference, if I was to boil both of these down into their most simple component, would be this. Non-probate assets are assets we know who gets them the moment you die, while probate assets are assets that we don't know who gets it when you die, so we have to look at the will to figure it out. Anything that's solely in my name and doesn't name a beneficiary transfers by my will. If I'm married and I own a house jointly and I die, my wife owns the property. We know who gets it because we know who gets it the moment I die. It doesn't transfer by probate. If it's solely in my name and I die, we have to look at the will to figure out who gets that home. So the first thing we talk about is transfers outside of your will, which we call operation of law. Like I said, we know who receives this property the moment you die. All we need is your original death certificate and we are good to go. And it needs to be an original death certificate. Most insurance companies, financial companies, banks, etc., they don't want to see a photocopy. They want to know it's for real. And there's a good reason why. They want to know they're not giving up your money for some fake document that looks convincing. Also, don't forget death certificates look different from county to county. So the financial institution isn't expected to remember how many counties are there in the United States? Like a bajillion. They're not supposed to remember all those. So you need to show up with an original. So what assets are transferred by operation of law? Well, these are assets that we tend to name a beneficiary on. Life insurance. When you had a life insurance policy purchased for you, you got it through your employer. You named a beneficiary. We know who gets that the moment you die. Your retirement plan. You hopefully named a beneficiary, and same thing, a contingent beneficiary, just like you did with your life insurance. So when you pass away, it doesn't transfer by your will. Joint property with rights of survivorship. Like I said, if I own my house with my wife, if I have a bank account and brokerage account with my wife, or my best friend, or the person that I only met once at a bar, but they sounded like they knew what they were doing, I can own joint property with them, and then when one of us dies, the other person can just collect it. They can also have full access to it, I should add. Anything that is transfer on death and in trust for accounts. We're going to spend a little time about that because it's a really important thing for smaller accounts and maybe for larger accounts as well. It covers trusts and different types of contracts. Like my prenuptial agreement may supersede what's in my will, and partnership agreements may do so. And we'll talk about all of these things. Jointly owned property. That is property that you own with at least one other party. I've seen joint accounts with 5 different people who were named on it. So go figure. I didn't think it was a good idea, but they were a family and they all trusted one another, and I'm glad it worked for them. All that the survivor needs to do is A, get your original death certificate, and B, hope that they survived you, right? If you survive the other account holder, you're trying to get their death certificate, but you don't even necessarily need it. Remember, with joint accounts, I can take all the money out. It's this weird, like, pseudoscience. It doesn't make sense, you know? Like, I'm waiting for Neil deGrasse Tyson to figure this out for me. When you own a joint account with somebody else, you both own 100% of that account. So you're not saying it's 200% of the account, you own 100%. So technically, you don't even need a death certificate. If you are changing a piece of real estate, which is in the form of a deed, you will. But joint accounts, not necessary. So you may still want a death certificate, just even if everything is passing by joint ownership, because maybe there's real estate that you need to pass, and then you need a death certificate. I can state in my will I leave everything to my wife, but if I own a piece of real estate or a joint bank account with my sister receives it, not my wife, because we know who gets this property, operation of law property, the moment I pass away. The positives is that joint property is easy to access for both owners, and there are minimal transfer costs. I just go to the bank and I take the money out of the bank, right? It's not a big deal. Or I can even leave it in there. Changing a deed for real estate costs a few $100. Negative, well, that depends on where you live. Here in lovely New York, we just bilk you for everything. So negatives are that non-trusted joint owners can empty out the account. This is always what I see for litigation, where mom says, you know what, I trust son and he'll take care of me, and she puts the money in a joint account so he can access it for her benefit, and then she dies and he's taken it all. I see that happen. There may be gift tax consequences. I'm probably not going to go over that much because that's only for people who have more than 11.4 million, the uber wealthy. Life insurance transfers outside of your will if you name a beneficiary on the beneficiary designation form. I want you all to take a note. Some point before the end of the year, I want you to check all of your life insurance, and I should add retirement plans, and make sure you have named the correct beneficiary. All right? Because that way the beneficiary just needs to show up with a death certificate and they are set. Retirement plans, which we're going to talk a bit about. We're going to kind of park here for a little while. It includes any IRA you have, a Roth IRA, 401ks if you have a 403b from a former employer. Those are retirement plans. The beneficiary, again, needs a death certificate and to be named the beneficiary on the beneficiary designation forms. Now, I like to spend some time on retirement plans because they have special estate planning treatment. The owner must begin taking, while they're alive, required minimum distributions once they turn 70 and a half. This only applies to the owner of the account. Required minimum distributions must be taken by anyone other than a spouse when you pass away, even if they're 5 years old. These are called, or this date, the 70 and a half, is called the required begin date. So when you turn 70 and a half, with a few exceptions, you are required to begin taking money out of your IRA. Now, I like to explain the different types of IRAs and investments that are out there. Remember, this is kind of the wrapper. Any of these categories can hold different types of investments. Cash, money market accounts. They can have sometimes Bitcoin. But they can't own gold for retirement plans, if it's like physical gold, but they can own gold in a virtual setting. My point is this, that this is the wrapper that owns the investment. Taxable funds are stuff that you have in like your brokerage account that's not your retirement plan, that Amazon stock that you bought outside of a retirement plan, your checking account. The downside of taxable investments is that they get taxed multiple times. When you earn the money in the form of an income tax, when you invest it and you get paid interest and dividends, you pay income tax on that. And then when you take it out, you pay capital gains taxes. So you get taxed a lot. You say, well, why do people want this? Well, because you still get upward potential. And you can put an unlimited amount of money in taxable accounts. You know, Elon Musk owns all of his money in taxable accounts, most likely. And anybody else who has all that money. Tax deferred, that's your IRAs and 401ks. That you don't pay money on. So if you make $2,000 a month and you save $200 of it in your IRA or your 401k, you're only paying income tax on $1,800. We only tax the money in those accounts when you take it out, right? So we're letting you not only hold on to the money and not get taxed now and get taxed at a later point in life when you probably have a lower income tax rate, we're also avoiding these dividends and capital gains. We're just getting taxed once. So we like tax deferred. We get a tax deduction now, and we get compounded interest as time goes on. And then there's post-tax accounts, things like Roth IRAs, muni bonds, your 529 plan that you set up for your kid or your grandkid. You pay income tax on the money you make now at Nielsen's, and then you invest it in a Roth IRA that invests in some type of investment, and you never have to take the money out again, or at least you never get taxed on it. You do have to take the money out at some point for some of these things, but I'll explain that piece by piece. The important thing is you never get taxed again. So this is post-tax funds. People call it tax-free. It's not tax-free. You pay tax when you earn the income. And again, here, if you want to go back later, you can see some of the positives and negatives that I put up here. You know, I would suggest if you have the opportunity, and plenty of financial planners can disagree with me. I'm a certified financial planner as well as being an estate planning attorney. So I have my own opinions, and I let everybody know all of them. Plus the fact that I think I know this right and other financial planners don't. But, and again, this is not investment advice. My feeling has always been a bird in the hand is worth two in the bush. So if you have a choice to donate money to your 401k plan or a traditional IRA or a Roth IRA or 401k, my feeling is to take the tax deferred option because you pay less income taxes now. I definitely get a benefit from saving money in my 401k or IRA. My Roth IRA, I probably do. They're probably never going to tax it again, but they could always change tax rates. They could always change required minimum distributions. They could say all of a sudden you have to take required minimum distributions out of your Roth. You don't know. You're putting a lot to chance because the benefit is in the future, not now. My feeling is save as much as you can in your 401k or IRA, traditional IRA or contributory IRA before you invest in your Roth IRA. That's about as much financial advice as I'm going to get, or give, I should say. These are the required minimum distribution rates for your 401k and IRA. I want you to see something interesting. When you turn 70 and a half from all of your IRAs, you have to take out 3.65% of all those accounts. So if you have $100,000 saved in your IRA, you take out, ready, $3,650, because that's 3.65% of $100,000. As time goes on, you have to take out more, right? So it doesn't matter how much your account went up or down. You could lose 50% on your account, and guess what? Next year, you're going to have to take out 3.77% of that decreased amount. I show this chart for this reason. There reaches a point somewhere around here where you're never going to make more money realistically, no matter how well the market does over the long term, right? Because if you're lucky, you're making, if you're lucky, 8% on average a year. Maybe 9 or 10, depending on how aggressive and if you time it right. And I don't want to put timing into this mix because you never time it right. There's some, nerd from MIT who created a program that's smarter than you. I got bad news for you. So somewhere around here, your account balance is going to decrease. The other thing I want to bring to your attention is this. Look how much the percentage went up when I was 70 to 71. It went up 0.12%. Not a lot, right? Barely a difference. Look at the difference here when I hit my 90s. I'm starting to go up 0.5% a year, even more. By the time you reach, I stop at 99. Once you reach the age of 115, you have to take out a little over half of what's remaining in your retirement plan, which by then is going to be like 20 cents anyway. And if you live to 115, like, good for you. I don't know if you even care. You probably didn't lead a miserable life if you make it to 115. At least that's the hope. Very fancy graphics. Now, required minimum distributions. Now you've died. I should have made that more clear. Boom. At this point, you've been alive. Boom. Now you're dead. You took RMDs. You were 72, and you left all the money to your spouse who's 20 years younger than you. Good news, because your spouse can transfer your IRA to their IRA. My wife's name is Michelle. The Daniel Timins IRA becomes the Michelle Timins IRA when I pass away. Why? Because I leave it to her, and I leave it to her as the beneficiary on the account. So she just shows up with a death certificate, and she can roll it over into her IRA. And since she's 20 years younger than me, yeah, I wish. Since she's, well, I shouldn't say that. Michelle, I love you. But if she is 20 years younger than me, remember I was 72, that makes her 52. She doesn't need to take required minimum distributions until the year she turns 70 and a half. And technically it's 71, but I'm not going to get into that. That's a step beyond what we need to get into. I always tell people if they want to leave money to anyone in particular, or if they want to leave it to their spouse in particular, an IRA is a good start. Even though they have to pay income taxes, generally speaking, it will increase your overall wealth. Because people say, oh, well, I'll leave it to my kids. Well, your kids don't get the same treatment, which you'll see in just a moment. I think the last thing to say is that your retirement plans, your 401k plan, is protected from creditors. When your spouse takes your IRA and puts your IRA into his or her IRA, it is protected from creditors. That is not the case when you leave it to non-spouses. So the Daniel Timins IRA that used to be transferred to the Michelle Timins IRA goes to instead my son, and that would be an awful name for my son, right? Timothy Tom Timins. The account is now named the Daniel Timins Inherited IRA for the benefit of Timmy Timins. Very different than the Michelle Timins IRA, right? It is an inherited IRA. You must take, meaning you as the beneficiary, because you and I are dead in this hypothetical, Timmy here, must take required minimum distributions even if he's 2 years old, right? Now it's going to be a low percent, but it still stinks because remember, minors can't own property. So I see this as a problem. People will leave their IRAs or 401ks to like their, 7-year-old grandkid, and they don't realize the 7-year-old grandkid can't own an account, and this starts generating income starting when they're 8 years old. They got to start taking out required minimum distributions. Not a good scene. The other thing is that inherited IRAs lose their creditor protection. I will add one side note because I don't think I bring it up here. If you have an inherited IRA and you happen to have a Roth IRA that is an inherited IRA, you have to take required minimum distributions. This is what I mean. If I, Daniel Timins, have a regular Roth IRA, I don't have to take required minimum distributions, right? I can keep it in the Roth IRA forever. But when I leave it to Timmy, he has to take required minimum distributions. He doesn't pay income taxes, but he still has to take RMDs because the government says we're not going to let you not pay taxes on this forever. And, to be fair, they're probably right in that case. You'll rarely hear me say that. I'd like to spend more time on designated beneficiaries, and I'm actually going to get a chance to do so. The important thing to remember is this. The way we figure out what your required minimum distribution is going to be when you die, in other words, your inherited IRA, is based on your life expectancy or the life expectancy of the beneficiary. A beneficiary must have a life expectancy in order to stretch their distributions and stretch their required minimum distributions. If I have one beneficiary on my 401k plan that is a charity, and I say I leave 99% to Timmy Timmins, my son, and 1% to, I don't know, the Hump Water Buffalo Foundation, which is a charitable organization. Timmy has to take all of that money out over the span of 5 years. Now, if Timmy isn't making a heck of a lot of income, not such a big deal. But what happens? I'm going to die if I'm lucky when I'm 85, meaning Timmy's going to be 60 or 55. He's going to be at the height of his earning years, and he's going to have to take out $500,000 over the span of 5 years. At the height of his income earning years. Bad news. When you name a charity as a beneficiary on an IRA, you got to make sure there's no humans on that IRA because you mess up the required minimum distribution rule for them. The charity takes it all in 1 year. My son or daughter wants to take it out over the span of as many years as possible. So I would not name a charity and humans as the beneficiaries on the same IRA. I would say create 2 IRA accounts. I'm going to have to skip this slide just because we don't have a heck of a lot of time, but I would suggest you read this when you go back. There are suggestions regarding when you do have your children named on your retirement plans. I know people are rushing to read it right now. Don't bother. I'm going to switch it. Okay. Which then brings us to in trust for and transfer on death accounts. If I have a bank account in my name and I say, you know what, my wife and I love her, but, I kind of trust myself more than her, and I don't want to have a joint bank account. But if I die and everything is cool, I'm willing for her to get it. I can create a transfer on death account. In other words, my bank account will look like the Daniel Timmins checking account in trust for Michelle Timmins, or the Daniel Timmins checking account or brokerage account transfer on death. Oh, the other way around. Michelle to Dan. I just show up with a death certificate from Michelle and her brokerage account becomes mine. She didn't want me touching it while she's alive, but when she's passed away, she's cool with it. I would suggest, and this is another one of those, take out your notepad and consider doing it, as well as checking your beneficiaries on your IRA and 401k. Go to your bank, and unless you have $200,000 in your bank account, like if you have a small bank account balance, leave that to your choice of beneficiaries. Name that account as an in trust for or transfer on death account. You name a beneficiary. If you have your spouse and 3 kids you want to name, you could put all 4 of them on it, and they each would get a quarter of it. That way you avoid having to go through probate with that asset. If you don't have any spouse, it's an even more important thing because at least your spouse has some rights to your property. I would suggest changing smaller accounts to in trust for and transfer on death. But wait until you see the other slides coming up. You can do this for real estate as well. This is what everybody seems to be doing here in New York. You can't do it in California or a few other states because it doesn't really work. But we do it now for mom and dad who are in their 70s or early 80s for Medicaid planning purposes. You can have your deed to your house be owned as a life estate. So you own it the rest of your life, and then when you pass away, your beneficiaries show up with your death certificate and it just goes to them. There's no need to probate it. This tends to be a good idea for parents who want to leave property to their kids but want to make sure they don't get kicked out. It's probably not a good idea when you don't want to leave it to a certain person, because then they don't even have to go to probate. They just get it because, again, we know who gets the property the moment I die. We do a deed change and it says, I, Daniel Timmins, retain a life estate and leave the remainder interest to my shady nephew, Robert. I don't have any shady nephews. I have nephews, but none of them are shady. You get the idea. So life estates are more or less transfer on death with real estate. Keep that in mind, especially if you have aging parents. I want you to talk to an elder law attorney and see what you can do. That's kind of like an optional 2A thing for you to do. Talk to an elder law attorney like myself or somebody else. So why wouldn't we leave all of our assets to beneficiaries as joint tenants or transfer on death, etc.? Why would we want to avoid giving it to them as operation of law assets? Well, you give up control when you pass away of the money. And sometimes the beneficiary is the worst person to leave the money to, right? Like your son or daughter who has terrible spending habits, you can only imagine what happens when you pass away and you leave them like a $300,000 life insurance policy. It is going to move, so you want to protect it. The problem is when you leave stuff to someone as a joint account holder or transfer on death, they get it in their pocket. You get no creditor protection. If they're a substance abuse user, that property is going to the drug dealer. You can't choose when a person receives it. So when you leave money to a minor, you're stuck. The court has to appoint an attorney because a minor can't own property in the United States, right? Whoops. So you don't want to name a beneficiary on a life insurance policy as a 6-year-old because it doesn't work that way. The court has to get involved because it's that minor's money and the money can't handle that $300,000. Can't choose how a person receives it. So basically someone says, I don't like this family stock, I'm going to sell it. Well, maybe they should, but again, if you leave it to them outright, you get rid of the choice. It's all their choice. And it can ruin a disabled person's Medicaid benefits. So if you have family members who are either younger or older and on Medicaid, remember, you can't have a lot of money and qualify for Medicaid. And yet now you just gave a huge infusion of $300,000 to someone who has cerebral palsy and has been on Medicaid their whole life, or at least their whole adult life. Big problem. If you have special needs family members, avoid doing that. You can leave these properties, however, to living trusts. And when I say property, I don't just mean real estate. I mean brokerage account, bank accounts, the sheerest definition of property, stuff that you own, personal property. A trust is a will substitute. So an attorney like me, I don't create joint accounts. You go to TD Bank or JP Morgan Chase. I don't create investment accounts. You go to Vanguard or you go to some other, whoever you go to. I create legal documents. And a legal document, such as a will, or in this case, a trust, is good because in a trust case, unlike a will, it transfers property outside of probate. There's no need to probate something that transfers under a trust. And because it's a written document, you can create contingencies that say, I leave everything to my wife, but if my wife passed away, I leave everything equally to my kids. But if one kid's passed away, his or her share goes to their 3 kids. And it goes to them at certain ages. And if the other kid has substance abuse problems, don't give it to them yet. Wait till they clean up. Or if they have creditor problems, let's deal with the creditors before anything goes into their pockets. Trusts are good for this reason because you're kind of like the puppet master, right? You control this property after you've passed away. And a living trust is great because there is no court oversight. I do want to say this is not a living trust. You can create a trust in your will that has pretty much the same terms as a living trust, and it is called a testamentary trust because it's created by your, everybody, last will and testament. A last will and testament creates a testamentary trust, which then brings us to wills and probate. We spoke about this last week, but probate is a legal process, like I said, where a court oversees the appointment of a legal representative, who we call your executor, who represents your estate, and they step into your shoes. They become you. They collect your assets after you pass away. Like I said, they pay off your creditors. They potentially bring or defend lawsuits, and they clean out your closet, and they give money either the beneficiaries or the trustee when the process is finally done. That is what probate and a will does, or probating a will. Now, if you have no will, and this is again for property that we don't know who gets it, like the bank account that's in my name that he didn't name a transfer on death beneficiary, well, it's still in my name when I die. And now we don't even have a will, and you say, it goes to the state. I say, no, it doesn't go to the state. Okay? This is what happens. If you die without a will, you're not the first person in your state to die without a will, and the state doesn't take the money. This is New York's example. It differs state to state. And again, I apologize for everybody who's in California, especially the people in California. I apologize. I lived out there. What are you doing out there? No, I'm just kidding. I loved it out there. In Maryland, etc. It's going to be a little bit different based on your state. But again, here in New York, this is an example. If I pass away and I have a spouse and no children, my spouse gets 100%. If I meet with a couple and I tell them, hey, without a will, if your spouse passes away, your surviving spouse and your children split the property 50-50. Would you say, I had no idea that's what was going to happen? Well, in New York, if you pass away, your spouse gets $50,000 off the top, and then the rest is split 50% to your spouse, 50% to your kids. And that's usually when I get the wife or husband saying, no way is that going to happen. We're going to do wills. Okay, fair enough. You can leave whoever you want, whatever you want, with some exceptions. But the important thing to remember is that you didn't draft a will in this hypothetical, so this is who gets it. If I never had a spouse or my spouse predeceases and I die and I have kids, it all goes to my children and then equally to my grandchildren if a child has passed away. If I have no spouse, children, or grandkids, it goes to my parents. Well, we're going to assume parents predecease us most of the time. So that goes to my siblings. And then if my siblings aren't around, it goes to my nieces and nephews. After that, if I have no siblings, no nieces or nephews, parents, children, or spouses, then it goes to my grandparents. Well, they're long gone at that point. So it goes to my aunt and uncle, and they've probably passed away too. And then it goes to my cousins. After that, if you have no cousins that are alive, the money goes to the state. You could have avoided this if you had a will, right? And here's why it's important to have a will as well. We don't live in a linear society, right? Some people have life partners. Life partners get nothing unless you draft a will. Your best friend, they get nothing unless you place it in a will. If you have no will, they don't get any of that probate property because nothing is getting probated. It's going through intestacy. Those people in the line of succession. So if I want to leave my cousin money because he gave me a loan, and then I pass away and I have a spouse and kids, my cousin's going to have a hard time collecting that loan. He could probably still sue my estate. But it would have been nice if I had dealt with my affairs by putting it in a will. Your pets get nothing. So remember, Leona Helmsley left her pets all this money. They get nothing. Actually, she left in a pet trust. Charities, organizations, and institutions get nothing. Your business partner gets nothing. And giving specific gifts to specific people. My best friend, I have a watch that I remember we found it together in the woods one day when we were kids, and I give it to him. Can't do that without a will. So important to keep that in mind. So what is transferred? Your will only transfers property you still own after you die. So stuff that we don't know who gets it, when there's no beneficiary named. A bank account, A car that's solely in my name or a home solely owned by you only transfers by your will, right? Because we don't know else who gets it. And if you don't have a will, it goes by that line of succession I showed you. Personal property can be transferred by a will. Anything that is not transferred by operation of law. And I bring this up because the next point, any property that is named my estate as a beneficiary. So I have a life insurance and retirement plan. And I think, like I said last week, remember this? I make an erudite decision. I say, I want this property to transfer by my estate because it makes me sound like I graduated from Yale and I'm smart. Well, the truth is, you made a mistake. Yale doesn't want you because now this property that was going to transfer easily outside of probate has to go through probate. Do not ever, 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 never, ever, ever name my estate as your beneficiary on any of your operation of law assets, your retirement plan, your life insurance. Heck, I even told you with your bank account, you should name a transfer on death beneficiary unless there's substantial money in there. Now, what is a will? A will is an original written or legal document. It doesn't have to be, I should say, typed document. You know, a photocopy will tends to not be good enough because who knows what it is? We have to question the witnesses. We have to question the drafting attorney. The witnesses can never be found. The attorney usually forgets or is dead themselves. You need an original will. If you have a photocopy, not good. If your attorney that you did estate planning with is holding on to your original will, do yourself a favor. Give him or her a call and say, I want you to FedEx that to me right now. That's number 3. Contact your old attorney and say, send me my original will. It's signed by you and witnessed by disinterested people. If I happen to be leaving everything to my home health aide and my evil next door neighbor and they are witnesses on the will, well, clearly that doesn't look pretty good, right? Because they were probably dishonest when they did that. So they have to be disinterested people, non-beneficiaries. It states who receives what assets after you pass away and names an executor, a legal representative to wind up your affairs. Plus, it can name a preferred guardian for minor children if you have one. It has to be submitted to a court, and the court, again, varies state by state, but you have to give the original will to the court that oversees the process. But it's only probated if you need to transfer property or a guardianship for your children. So again, these are the legal processes. If you have a will, it's called probate. If you don't have a will, go down. It's administration, at least in New York. It's going to be a little different in other states. Responsible party is called an executor under your will. And if there's no executor, so you don't have a will, it's called an administrator. Who gets what? You can choose in probate, but when you don't have a will, you can't choose. It's the state's default. So important. Now, here's the thing. When I have a will, these are the people in line that have to get placed on notice. And the funny thing is, remember this slide? We had one very similar to it if you pass away without a will. If you do have a will, these people must still get placed on notice. Here's what I mean. I don't have a spouse or kids. My parents pass away. And I love my brother, but I hate my sister. Well, when I die, my will says I leave everything to my brother, but not my sister. Here's the problem. My sister is still my next of kin. So my sister and brother both get the will. Even though my sister gets read, I hate my sister, I think she's ugly, I'm not sure she's actually my sister, I don't leave her anything, right? Doesn't work like that. She has to get a copy of the will. If she passes away, it's her children, my nieces and nephews, that take over that right. Just because you leave property to someone does not mean that the people you disinherit don't figure it out. In fact, the court requires your next of kin to be placed on notice because that's how we transfer money by default in the United States, to family members. So keep that in mind. If you're disinheriting people, doesn't mean that person isn't going to see your will. And that list of priority is important because it shows who gets what money if there's no will, remember, intestacy. Who gets put on notice if there is a will. If I pass away and I have kids, but my aunt and uncle say, hey, we want to act as, want to get placed on notice, they don't get the right. Or if they say, we want to act as executor under the will or administrator, my kids have the right to dispute that because they're the next in line. And who can legally contest the will? That's important. So if you pass away and you have nieces and nephews, but you want everything to go to your cousins, remember your nieces and nephews are closer to you blood-wise than your cousins. Your nieces and nephews can fight the will. So it's very important to plan these things out. Now, what does the court do for probate? The court approves or disapproves of your choice of executor. They usually approve it. They can require that they have to account for all their actions. Remember, a will is in public until you die, and then it actually has to be submitted to the court. And the court only probates original wills. Photocopies are typically proven to be invalid. You can do a lost will proceedings in some places, but don't do it. What does your executor do? Your executor, quote unquote, like I said, steps into your shoes. They collect your probate assets. Your non-probate assets transfer outside of probate, like your life insurance, your retirement plan, so it doesn't work. They pay your funeral expenses. They pay creditors and any taxes that you have. They can hire help, such as accountants or attorneys or movers. They can get your original medical records so they can bring a wrongful death lawsuit, or can show that you had mental capacity to execute the will. They can bring a lawsuit on your behalf, not just wrongful death, or defend it. They clean out your closet, and then they give the money to the beneficiaries or to the trustees. So your executor, we say, does everything you can do. They close down your affairs. Now, they can't just start paying off beneficiaries necessarily immediately. There's an order of who gets paid from your estate. The first is your funeral home and burial costs, because even attorneys don't want to deal with that. They say, all right, that seems fair. Getting your body in the ground or cremated is important. So that's the first parties that get paid out of your estate. After that, let's be honest, you knew the attorneys are going to get in there pretty soon. We're number 2 with accountants and any court fees that are paid. So we get paid second. An executor is entitled to a commission next. It doesn't mean they get paid there, but it means that in the list of creditors, they're number 3. They are ahead of preferred creditors like the IRS or a mortgage. They get paid because without an executor, no one can get this job done. So it's important to remember your executor does get paid, and I'll show you what they typically get paid in New York. It differs state to state. After your executor is preferred creditors. That's the government or the mortgage on your house. Then non-preferred creditors, your credit card bill, medical bills. When you pass away, you tend to have a bunch of medical bills associated with it. After all of these parties have been paid, finally, beneficiaries are paid. That's what matters. All those parties have to get paid first. Nice dramatic drop. This is what New York's executor commissions look like. You know, I hear people say, oh yeah, my aunt's executor got paid 20%. Well, they either ran away with the money or you didn't understand what was going on. All right? Because that's not what executors get paid. Unless it states in the will the percentage the executor gets paid, this is an example of a default. All right? For the first $100,000, if you die and you probate a will in New York, the executor is entitled to $5,000, 5%. 4% on the next $200,000. So if I die with $300,000, I pay 5% on the first $100,000 and 4% on the next $200,000, which is $13,000. For the next $700,000, so up to $1 million, I get paid 3%. So you see, each time you go up a dollar amount, the percentage you get paid goes down on the next dollar. So if you pass away with $1 million transferring through probate, it's $34,000. And again, that's simplified. And if you pass away with $5 million, I believe it's like $128,000. Thereafter, anywhere over $5 million, if you have more than $5 million, why don't you give me a call? Let's hang out sometime. I'll buy you lunch. Your will states your choice of your child's guardian. Remember, you can't ultimately choose your child's guardian. You can put your preference, but the court's always going to ask what's in the best interest of the child. So like we spoke about last time, sometimes I say perhaps a little too much, but let's just get right to it. If you name Lester, your molesting uncle or cousin, as the person to be a guardian over your children, and the court knows about it, Lester is not going to serve as guardian over your kid, right? The court can say no, and the court can take your kid tomorrow, which is kind of scary, but it's true. But you can state your choice, and this is good when you and your spouse or the child's other parent, if they're not your spouse, agree to this. Because God knows plenty of spouses get divorced, even if they do have kids, and plenty of people have kids outside of wedlock. Facts about wills. So if you drafted your will in Pennsylvania and now you pass away in Virginia, your will is valid under the full faith and credit clause of the Constitution. So that's great. As long as it was valid when you signed it in Pennsylvania, it's valid in Virginia. Now, you can use your U.S. will to also transfer property that you own when you die in foreign countries, at least several of them. Not every single one, but most of them. The court will hold on to your original here, and then they'll create a court-certified copy that you would then send to the court in that other country. Now, you may still want to use your French will, for example, to transfer your property in France. That's something you may want to consider. And the other reason is because here, if I'm sending my will to Taiwan, well, I got news for you. Everyone speaks English, but not necessarily. And then let's say I was in Taiwan and I had a Taiwanese will drafted, and now it's getting translated here in the United States. It costs an additional fee, right? It's valid, but it's confusing because, quote unquote, things get lost in translations. I tell people when someone promises them that they're going to get something, that they should tell that person to give it to them in writing. This is what you're going to see. Aunt May said that I'm supposed to get her engagement ring. Well, then she dies and the will is silent. You don't get the engagement ring. The fact that someone says something has very little probative value. Remember, we're talking about the law. The law likes things in writing. It's annoying. So we say there's no dead man's rule because we made it up before we had this very gender sensitive world that we live in. But it means that anything a dead person says to you does not apply. There's no dead man's rule here in New York and in most states. Get it in writing. Now, what is a trust? We were speaking about wills. Well, trusts are the other document that people like me create. Again, it's a written document that deals with three different parties: an administrating party, a beneficial party, and a creating party. And it states the terms in which people receive money. It avoids court oversight if it is a separate trust as opposed to a testamentary trust created by your will, which continues to exist after you pass away, and it only impacts property owned by the trust. You can have three wills, but they typically invalidate one another. But you can have three different trusts. You leave something to your wife, you leave something to your grandkids, and you leave something to, I don't know, Fifi, your partner on the side you didn't want people to know about. But guess what? Your executor can figure that out. The names of these types of trusts tend to be something like the Daniel Timins Revocable Trust. I can change it. The Robert Rogers, I should change that to Roger Rabbit, Living Trust. Or you can be secret about it. You can say, you know what, I'm a celebrity, or I feel like I'm a celebrity. I deserve to be a celebrity. I will be a celebrity when I go to a reality television show. So you could own property in an irrevocable trust called the 123 Rebecca Irrevocable Trust. Shout out to Rebecca. Love your show. Now, trusts, who are the parties? There's the creating party. That is called the, because we're dumb in the law, believe it or not, the creator, but we also call them the settlor and sometimes the grantor, because we'll come up with three names of things just to confuse you. There's the trustee, the party who manages the property, pays the income taxes, invests the property if it's not real estate, like an investment account, they could change the investment. And then there's the beneficiary who just sits back and enjoys the cool, hard cash. So things to remember about the differences between these, and I hate this color. I'm going to change this next time, I promise. But probate is public, trusts are private. There's no court involvement. With wills, the burden of proof is on your executor to prove it true. So there's a lot of work the executor has to do. With a trust, if anyone's fighting, they have to figure it out. And the trust isn't public, so it's hard for them to figure this out sometimes. Wills are slow and expensive at the back end because you didn't do any work. Trusts are fast at the back end because you did all the work up front. And here's why. Let's look at the very bottom line. Just need to execute the will to be effective. I'm basically saying with the will, I'm just drafting this document, and I'm signing it because I'm going to let someone else deal with it later. Whereas a trust says, I'm going to have property named after the trust now, so when I die, no one needs to deal with it. It's already taken care of. And again, with living trusts, we talk about during life why you would want one, because during your life, it's continuity of finances. If I get incapacitated, if I have a stroke, my trustee will then be my wife or my kids or my brother, and he'll continue to use the money for me. And after life, there's privacy, and like we said, it avoids probate. It's fast distributions. It takes me somewhere between 3 to 6 months to actually access property here in New York if it transfers under a will. With a trust, your body can still be warm. As long as I have an original death certificate, an attorney like me can help your family collect that type of property that's owned by a trust. Remember, a revocable trust tends to be you as all three parties. Remember, you are currently creating money and you're administering to it, paying your bills, so you can go out to dinner and buy cable and watch Netflix and chill. Because you're all three of these parties, this is considered a disregarded entity. And that disregarded entity very simply means that you don't get any creditor protections. Well, let's go over irrevocable trust to show you why you would want an irrevocable trust. That's a revocable trust. There are only 3 reasons why you want an irrevocable trust, and here they are. because you want creditor protection. So you're someone who gets sued. Like if you're, like I say, if you're an OBGYN or in construction, or, you know, you just like a really bad dude and you get into a lot of fights, you may want an irrevocable trust that gives you creditor protection. A revocable trust doesn't do that. Irrevocable trusts can reduce estate taxes for the wealthy. I don't think there are too many people here worth over 11.4 million, but if you do, let me know. And then government programs. If you have an aging parent who has a stroke or some type of disability, an irrevocable trust is what is required for Medicaid purposes. In an irrevocable trust, here's the big burn. You can either be the trustee or the beneficiary, but you can't be both, right? There's a big wall over here. So I should probably take this out, which I'll do next time also. Anyone other than the beneficiary can be the trustee. Anyone other than the trustee can be the beneficiary. So that's how we create protection, because this person could say, no, not giving it to you. You know, your kid who's a bad dude, well, if you pass away, you don't want him getting at the money, the trust becomes irrevocable. You could say, your Aunt Selma is going to be your trustee because I don't trust you, son or daughter. I pick on guys a lot. Daughter's turn. Okay. Funding trust. Remember, you have to change the name of the property to the name of your trust. So a current asset, such as changing a bank or brokerage account to the Daniel Timins Revocable Trust, or the deed to real estate. And if you have future assets like life insurance, remember, life insurance really doesn't pay you much right now. You just pay in. But when you die, it's worth a heck of a lot of money. You want to name your trust as the beneficiary of your life insurance policy. You may want to name a trust as the beneficiary of your retirement plans, typically not when you're married and you love and trust your spouse, but when you don't love and trust your spouse, but you feel like, just obligation, that's another story. You may want to leave it to a trust. Again, trusts avoid creditor claims and beneficiaries' personal problems. If they have spending problems, protects it. Substance abuse problems, not giving it to the beneficiary because it's going to the drug dealer. Marital requirements, if your spouse is in the middle, or your child, I should say, is in the middle of a fight, or they say, hey, no, I love Todd even though he has 17 tattoos. I trust him. I don't want to sign a prenup. Well, you can protect your money by placing it in a trust. And you can choose when people receive the money. So prior to 35, here's the plain vanilla attorney approach. Prior to 35, money can be used by the trustee for your kids or your best friend or your family member for their health and education. At 25, they get a quarter of the trust. At 30, they get a quarter of the trust, which is actually a third, because I figured out one day that a third of 3/4 is still a quarter. So, go figure. It took me 5 years to figure that out. And then 35, you get the rest of the trust. Hey, I have an advanced degree, but it's not in math, so please just bear with me. Last but not least, naming the right trustee. Again, you want to name someone that you trust. If you don't have anybody you trust, you can name a bank or a trust company. I'm not big on that, but in some cases, that's what you got. Because you can name your attorney, your accountant, or your wife, or your husband, or your uncle, or your best friend. But sometimes no one wants to do it because the beneficiary is such a monster. I want to keep that in mind. I would love to go on over more unforeseen problems. My general feeling is that you should watch out for doing things on your own because you don't know what you don't know. The hit that's going to hit you is the one that you don't see coming. Providing funds for your bodily remains and initial estate costs. When you pass away, it's hard to access your money, remember? So that's another reason to leave your transfer on death money to beneficiaries so that they can pay for your funeral expenses. Because unless you prepay them, they're going to be stuck. Someone's going to get stuck. It could be your estate, but you don't get a great burial that way or a great cremation or ceremony. So you're going to want to deal with that. Remember, if you leave money to minors or disabled individuals, boom, you can really mess things up. You're going to get, in the case of minors, the court appointing the judge's golf buddy or campaign contributor. We're going to call them a guardian ad litem. And then lastly, leaving money to disabled beneficiaries means that you could kick them off of benefits like government programs. Now remember, you often need original documents. Healthcare proxy from last week, not so much. Power of attorney, sometimes. A will, you need it once you pass away. I tell people to keep it in a safe at home or even in a file cabinet. A safe deposit box is bad because it's hard to find out about them. So if you don't tell anybody about safe deposit boxes, you're really putting them in a bad place. If you can't find certain family members or beneficiaries, the court needs to appoint an attorney to represent them. You're not just cutting out your sister because you can't see her and you don't like her and you can't find her. right? You're going to need to have the bank, excuse me, the court hire somebody to represent her. Here's some warnings for do-it-yourselfers. I would have loved to have spent, like I said, a little bit more time on that. I want you to go back to this slide and read the mistakes that people can make. Again, it's usually not the document that's wrong. It's usually the execution. I execute a heck of a lot of wills and have a heck of a lot of experience regarding them. So the do-it-yourselfers they have to realize that many of your assets pass outside of your will. Let the executor of your will know who your closest relatives are and where they're located, because you have to put them on notice. Make a list of all valuable personal property that you have and share it, because otherwise someone's going to break into your house and run away, and it could be a family member that does that. The first person who gets there gets it all. Let the right people know where your original will is located. The person you disinherit, don't tell them, hey, I disinherited you, Timmy, and by the way, the will is right under my bed. That's a recipe for failure. Do not have assets pass directly to disabled beneficiaries or to minors. Do-it-yourselfers always have to keep this in mind. I want you to include the contact information for your next of kin, the executor or executors to your will, your witnesses, and this is a good idea. You also want to put people on notice who your financial planner, your accountant, and your attorney are. Write it down on a piece of paper with their contact information and give it or place it with your will or give it to the beneficiary or the person who's going to be your executor. That does it for me today. I'm sorry I rushed through the last 5 or 6 slides. I could probably talk a heck of a lot more, but I would rather hear from you.
All right, thank you so much for that. I do have a couple questions so far, so we'll try to see what we can get in the next few minutes. The first one that I have here is, if you are adopted, but at some point you found you have an entire biological family, mother, father, brothers, sisters, etc., um, do they have no legal rights to your money or assets, or do they have rights?
That's the hot new thing, isn't it? You did 23andMe or Ancestry or some other genetic company and you found out, whoa, look at all these assets I have. Or even worse, someone else is adopted out of your family and now they're coming after your estate. They have no right. Adoption supersedes parental or biological law. And in fact, if you're a stepchild, you're not entitled to your step-parents' money either. All right? You want to be adopted if you want rights. But again, if you get adopted out by a rich family and now you're adopted by a poor family, you're stuck with the poor family. No rights.
Gotcha. Thank you.
Mm-hmm.
The next one, in regards to trust, is there a minimum net worth recommended for setting up a trust? And then what is the typical, kind of a two-part question, what is the typical cost, lawyer fees for setting up and funding a trust?
Great. Okay. I'll answer both of those. There's typically not a dollar amount. It's more so the situation. So I have some people who need to get onto Medicaid and they have $80,000. And in New York, that's about $65,000 too much to qualify for Medicaid. That's not a lot of money, right? But you place it into a trust, qualify for an irrevocable trust, thereby making you qualify for Medicaid. So the dollar amount doesn't matter, it's the need. Now, for a standard revocable living trust, if you have multiple pieces of property or you have assets that are illiquid, you probably want to have a trust. If you have a lot of family members out of the country, you want it in a trust. If you want to keep things private, you want it in a trust. So it's not really the dollar amount, it's the complications that are associated with probate that makes trusts favorable. As far as cost goes, I'm living in about and practicing in probably the most expensive place to practice law in the United States. Maybe Silicon Valley matches us. Typically the cost for a trust in the New York City metropolitan area is probably somewhere between $1,500 to $5,000, depending on the complexity. I figure it's going to be about $2,500. If you're talking to us from Wichita, Kansas, you're probably going to get your trust for less than $1,000. But again, I can't tell you with certainty. It varies really state by state and location by location.
Great, thank you for that. That's actually the rest of the, or just comments to thank you, for the presentation, a lot of information. Everybody appreciates that. And I just want to end it with saying, at the beginning of this, Daniel, I told you that I appreciate you talking, for lack of better words, on our level, and kind of putting it in layman's terms, providing scenarios, things like that. And I really appreciate that because it helps us better understand it, better understand our options and the best choices. So I really do appreciate that and your time today.
Thank you, Kate, and thank you, Nielsen.
Thank you, everybody, for joining. And a recording will be sent. So if you know anybody that joined today and wasn't able to attend, a recording will be sent afterwards. So thanks, everybody, and I hope you have a great rest of the week. Thank you, Daniel.
Thank you.
Thanks a lot. Take care, everybody.